What you know, Alibuyers. Hope you're having a great day. We watched the Donna Adelson hearing earlier this morning, but the audio was terrible. So I went in and cleaned that up a bit and wanted to post the hearing with a little better audio for those of you who struggled to understand what was being said and for those of you watching it for the first time. All right, we'll see you soon. I'll put an episode out later summing up what happened during this hearing.
Wendy. Of course she did. She did like 5 and she I already did.
Was family asking to be on Zoom once again?
I do not know the answer to that, Judge. I'm sorry. Let me confer. I think we should probably assume so.
What I've seen, I see a time with my phone.
Okay, then yes, Your Honor. Thank you.
Do you have any idea who you should join us with?
I do not.
The only reason I'm asking is because in the last hearing, someone joined Zoom who's doing inappropriate things. So here, the Zoom is going to be limited. If I would blame to everyone else trying to do inappropriate things in the midst of the Zoom, ultimately it's just going to be, if you're here, you're here, you're not, you're not. And go ahead and allow our parties to make their appearances for the record.
Georgia Kappelman for the state, Your Honor.
Sir, Captain Dugan for the state. Dan Ashbaum on behalf of Mrs. Adelson, be present. Alice Morris on behalf of Mrs. Adelson.
Very well, let's go ahead and move with the lunch hearing that was scheduled for today. This is the chairman's motion in limine concerning the testimony of Sgt Corbitt and the summary exhibit. Whoever's arguing the motion may proceed.
Judge, I think we filed pretty detailed papers on this. So I'll quickly summarize, and then if you have any questions, I'm happy to answer anything that you have. I think it's really important to realize we're not asking that he not be allowed to testify. What we're asking for is 2 pieces at this hearing, and there'll probably be more during trial regarding actual pieces of his testimony. So that's the 3rd piece. The first thing we're asking for is that he not be qualified as an expert. We don't believe, as set forth in our papers, that he's testifying to anything that meets the standard of Florida statute 90.956. And so we don't think he meets the qualifications of an expert in what he's testifying to.
You mean 90.702?
90 correct. We don't think he meets those qualifications. We think he is a summary witness, not an expert witness, and we think his report illustrates that. The report itself has essentially 5 components. It has emails, which are a culmination of emails that the state has taken and put in a report. Text messages, neither of which emails or text messages is he an expert on. He's just compiling them, putting them in a report. Video surveillance photos, and then it has call record summaries, which we'll get into, but takes no expertise to do the call record summaries. Florida law is pretty clear on that, as well as cell site data, but it's very limited to cell site data, especially with regards to Mrs. Adelson, who's on trial here. There's some more detailed cell site data with regards to Mr. Garcia and Mr. Rivera. But even that wouldn't qualify as expert testimony. The cell site data as to Mrs. Adelson, there really is virtually none of it.
So one question before we continue on track with the expert testimony. As it relates to items that the state can properly admit, and I'm sure that based on the pleading, there are aspects of the current PowerPoint that are disputed as being inadmissible. But for what can be properly admitted, are you also disputing that those cannot be used as a demonstrative during trial by the state in some way?
No, they can be. So, in other words, there's no dispute that they can use the report as a demonstrative. There's no dispute that for the admissible items, they can put in the admissible items. So I'll give you an example. Email between Wendy Adelson and Donna Adelson. Clearly it's admissible, provided it's relevant. The ones they provided are relevant. Clearly admissible. The underlying email can be admitted, shown to the jury through an appropriate witness, if they call Wendy Adelson, for instance. Okay, so that email is admissible. But the summary of the email in the exhibit, the summary of the 1 or 2 page email in this exhibit can be shown to the jury, but it doesn't qualify as expert testimony or a proper summary exhibit to be admitted. Does that make sense what I'm saying?
It does. The one thing I would, the only one thing I would question even concerning demonstrative, are you also saying the state cannot put the context around these various pieces of evidence?
No, that they can, right? They can make arguments just like they do in closing arguments, right? They can show the exhibit to Corbitt, Sgt Corbitt. He can put it on the screen. He can explain whatever he's going to testify to. Our argument is he's not an expert in doing that. That's our first argument. And our second argument is ultimately that 329 pages right now doesn't go back to the jury. It's a closing argument, essentially. When you look at his 329 page exhibit, and again, I'm getting a little ahead of myself, but when you look at his 329 page exhibit, it's essentially Ms. Kaplan's closing argument, okay, which we don't admit to the jury. The jury doesn't get her slides and see them in the jury room when they're deliberating. But no, of course, they're able to provide its admissible material in it. They're allowed to show the exhibit. They're allowed to use it as a demonstrative. They're allowed to question Sgt Corbitt. He is allowed to be a witness based on what he did. Our argument is, number one, he's not an expert, and number two, the actual exhibit is not an appropriate summary exhibit that would go back to the jury during deliberations. That's what our memo is about. And it's supported, Judge, by Florida law. So the Florida Supreme Court has held that law enforcement testimony, which merely summarizes and explains data from cell detail records, including the mapping of cell phone location data, is not expert opinion under Florida Statute 90.702. And Daubert, because it involves no scientific, technical, or other specialized skill, cites King v. State 260 SO 3D 985, Florida 2018, McMillan v. State 214 SO 3D 1274, Florida 217. The Florida Supreme Court has supported that, and also has the 11th Circuit in Batista, B-A-T-I-S-T-A, in affirming the Florida Supreme Court, where the 11th Circuit of Court of Appeals affirmed the district court's decision to admit as lay testimony an FBI agent's use of cell phone records, along with the phone company's records of where their cell phone towers were located, to plot on a map which towers connected with which cell phones at a particular point in time. But it said it wasn't expert opinion. It said that you don't need the agent doesn't have any expertise to read the cell phone records to determine which cell tower was used at a particular time, look up the latitude and longitude of that cell tower in the company's records, and mark the intersection of the latitude and longitude on a map. That's precisely what Sgt Corbitt is doing here. It is exactly on point to what he's doing here. Also, the fact that he pulled data off of iClouds and he pulled data off of iPhones, it's not expert. Now, of course, he's able to testify to it, but it doesn't meet the standards of expert testimony. Now, moving to the second point, Judge, which is
Before you move on out of that, when it comes to the data pulls, because I've heard this argued, not maybe the number of ways over the years. The first being the data pull itself is a factual issue, which I would agree. How the machine works and whether or not the data pull was in fact, or it took place technically in a correct manner, that goes to more specialized information. Is there going to be any contesting of any way that the data pull was somehow not technically proper or sufficient? Because if so, at that point, now we are veering into a matter that deals with specialized information, knowledge, or expertise.
Just may I have one moment, please?
Go ahead.
You've stipulated to that. That's not anything you stipulated to. All right, so I'll have to figure that out.
We're okay, around the station. Judge, I don't believe it's going to be an issue. But we understand what you're talking about. If it were to become an issue, then obviously the expertise on that particular issue would be obviously subject to his qualifications, which we think he has. Okay, but at this point, we don't anticipate it being an issue. We don't anticipate, there may be questions as to why he pulled it as opposed to someone else pulling it. But as far as whether it was pulled appropriately or not, we're contesting that.
Well, you may continue.
Okay, so if I may just move on to the second part of the argument. The second part of the argument is not dependent on the first. So whether he's an expert or not an expert, it really is an independent inquiry, the second part of the argument, which is whether ultimately whatever turns into his exhibit is demonstrative goes back to the jury. And again, for purposes of today, unless you want to go into it, I'm not going to be talking about specific pages that we don't believe are admissible. So let's just talk about the thing as a whole, if that's okay with the court. So, Judge, this summary, and I think you've had an opportunity to view it. It's not, the first thing to understand is it's not a neutral summary. That's the first thing to understand. The second thing not that alone does not end the inquiry. It's just a fact.
Well, to that, and obviously a criminal case is different from a civil case, but all the time, in civilly related matters, parties will have presentations, reports, summaries prepared. The plaintiff, by nature, is adverse to the defendant. Anything that they're preparing for the jurors is going to advocate or in some way demonstrate why I should win. As it relates to this summary, the state is prepared with in anticipation of litigation to advocate their position. Why is this inappropriate?
That alone, that fact that it's not neutral, is not the determining factor. But it's one that courts would tell you to look at in deciding whether it is a summary that's appropriate to go back to the jury or whether it is more in line with a closing argument, which would not be appropriate to go back to the jury. So I start with that just because it's just as a basic factual point. I don't think it's determinative of your decision. What is determinative of your decision, though, is when you look into summary, it's full of items. Again, we're not disputing that the items are admissible. Let me be clear on that. So the summary has, for instance, I think at last count, 30 to 40 emails. Those 30 to 40 emails, provided they survive evidentiary challenges, are admissible. But a summary is done for the purpose of taking voluminous records and synthesizing them in a way that helps the jury. That's what the statute talks about, right? And that's what the case law talks about. That's what Oyede talks about, which is 933 F3rd 302 310 4th Circuit 2019, where it talks about how we don't send closing arguments back to the jury. That is not admissible under law, because summaries are elevated under Rule 1006 and also Florida Statute 90.956 to the position of evidence, care must be taken to omit argumentative matter in their preparation, lest the jury believe that such matter is itself evidence of the assertion it makes. So in this document, you see a bunch of items that are not voluminous. They're one page. Rental car agreements. There's no summary needed for that. 2-page emails, 1-page emails. There's no long emails. 1-page text messages. Not necessary. And then you see call records, and you see some call summaries. Again, not voluminous materials. I wish they were, but they were limited in what the call materials were. So, Judge, our argument is that the exhibit itself can be shown. We're not arguing that it can be shown to the jury.
As demonstrative, but not as admitted evidence.
Admitted evidence. The underlying evidence in it that's admissible can be admitted, obviously. Now, we need the summary, and I think this may be better taken up at trial or in another day, unless you want to take it up now. Within the exhibit, we all...
As to any pages that are specifically disputed as inadmissible, it's best to handle this outside of the presence of a jury, so that way it's clear what is in and what is out when all of it is ruled on.
Yeah, so I mean, we can do that at your convenience. Look, the state has still been updating it, so things may change, but we already see some pages that are either hearsay or privileged under the joint defense privilege, for instance. We already see, there's not a lot, but we already see some pages that we think are problematic, and we can take that up whenever you want. But our argument today summarizes on his characterization as an expert, and either way on the document actually going back to the jury.
Let's handle that part of it then next Thursday. There are still disputes as to individual pages, so that way it can be handled and ruled upon.
Okay, thank you, Your Honor. If you don't have any questions, we'll rest on our papers.
Very well. State, you may respond.
Morning, Judge.
Good morning.
So the defense motion argues that, you don't have to be an expert in order to testify to phone evidence. And they cited the King and Gordon cases in their motion and talked about them this morning. I think it's important to consider that in both of those cases, which were post-conviction motions, where the court said that the defense was actually not ineffective for not getting their own expert or not objecting to the witness testifying for not being an expert. The defense did not object to a non-expert law enforcement officer testifying to the cell phone evidence in that case because it was a strategic decision. The defense knew that they could cross the law enforcement officer more effectively than an expert, and the state could easily get someone more qualified had the defense objected. In Gordon, the court said that the witness from the phone company who testified would have qualified as an expert to testify to that data and been able to testify to the cell site data had there been an objection. In King, in that post-conviction evidentiary hearing, the defense put an expert on the stand who provided expert testimony on GPS and on cell phone location data. The defense expert concluded that the defendant could have been at home, not at the crime scene at the time of the murder. So in that case, there was an expert who testified to the location information from the cell phone records.
That does lead me to my first question concerning Sgt Corbitt. What exactly is he going to testify to beyond what the cell phone data history records or cell phone tower records would show? That otherwise you need him to testify through an opinion that he cannot just testify off the records themselves.
Yes, sir. So he's going to be, and I have this in just a second, but as far as the summary goes, he's not testifying as an expert to everything in the summary, but he's testifying as an expert to a large part of the summary when it comes to cell site location data and how far, who's using a handset at the time and how far the person is from the cell site location. He uses the more.
You're saying how to interpret that data.
Yes, sir. And he uses more than just cell phone records to do that. But the cases, the Gordon and the King cases, those cases say a witness does not have to be an expert to testify to some of that information. But they're not saying that you cannot present an expert to offer an opinion on a handset's location. If that witness has the necessary training and experience, just as was done at the hearing in the King case and could have been done at the trial of the Gordon case. And Sgt Corbitt has hundreds of hours of training and experience and has offered an expert opinion well over 100 times in circuit court. The reason they don't want him to be able to declare an expert, they don't want him to be able to offer an opinion. And this is more than just a data pull of, hey, we got these cell phone records. And this is more than just, this is where the cell site locations are at any given place in Florida. This is him forming an opinion on how far a handset is from a location, who may be using the handset at the time that you need this specialized, or that it's beneficial for the jury to hear his specialized knowledge because he's able to interpret the cell phone records to tell us that information. The defense also argues in their motion that there's basically just too much evidence in this summary, that it's more than just for phone records and some of the evidence isn't voluminous. But a summary's whole purpose is to summarize relevant evidence. Sgt Corbitt, as I said, is not offering an expert opinion on everything in the summary. He's offering an expert opinion on the interpretation of the cell phone records, the location of the handsets, who may be using the handset at the time. And there's a large part of the presentation that are those things, but there's a lot more information in the summary, like surveillance video from Premier Jim, a traffic ticket received by the suspect, a car rental agreement, that maybe those things individually aren't voluminous, but they're all material to the presentation and material to his opinions because he's using them to provide an opinion on who had the handset and where the handset was at the time. For example, if a certain suspect's phone is communicating with a cell site that's consistent with like a car rental company, an expert may be able to better determine who was using the handset at the time and confirm their actual location and confirm the reliability of the cell site information. If we're able to see that, well, that person actually got a rental agreement at the time, they got a traffic ticket shortly after the car was rented, all of those things help him form his opinions and determine that. The defense says, this is a closing argument. The information that he looked at in this case, there is so much digital evidence that it is very all-encompassing. However, there's not what's in the presentation is not. It's all data. It's messages. It's emails. It's different business records and cell phone records that we received that helped inform those opinions. They talked about the 30 or 40 emails. When I'm handing them over the things that I may use in my presentation, I'm trying to be as thorough as possible. I don't want them to have less information than I may use. I don't intend to use all 30 or 40 emails. I don't intend to have Sgt Corbitt sit up there and read all of those, but I wanted to send them all of the ones that I may use as far as just, these are what was found in these different accounts. This was and asking him, hey, did law enforcement find some evidence of motive that caused them to look into these people? Yes, X, Y, and Z were found. Maybe spend 3 minutes to 5 minutes on that and move on to the next thing.
As to that point, I believe the defense's motion hits on this as well. For what you would ask Sgt Corbitt to add to this, is that in fact his opinion?
So the defense motion attacks that, the prosecutor is ultimately deciding what's going into the presentation. Maybe that's what you're referring to.
Yes.
But Sgt Corbitt's job is to pull information from these devices, interpret that data from the cell phone records. He's not investigating or prosecuting the case. In the investigative phase, he has to rely on the investigator to let him know what he's looking for, what this proverbial needle in the haystack is, whether he's wondering it exists. And Sgt Corbitt's then looking through the records to see if there is one, and then if there is one, including it and letting them know. Sgt Corbitt doesn't know exactly what the prosecution wants to present at trial. I talk to him about what the records show. I ask questions. He looks for answers. He lets me know what the data says. And then I'll say, yeah, can you put that in there? I think that that's important. He's not the one talking to witnesses. You know, I may talk to a witness. They tell me a certain event occurred. Then I go back to Sgt Corbitt and say, hey, is there any evidence of X happening? And he lets me know that may corroborate what the witness says, and then we're able to put it in there. And I'm not able to get that information in any other way because he's the person that's looking in these cell phone records and can let us know whether that evidence is corroborated or not, and can provide an opinion on what the data shows, where that handset was at the time, where that how far they were from the tower at the time, things that may corroborate witness testimony or appear in the cell phone records that I wouldn't be able to see or know on my own. The defense motion also argues that the summary isn't admissible, but summaries are admissible. That's the whole point in using them, and there's no case law that I know of that says otherwise, that a summary isn't admissible. It has to only be used as a demonstrative, and the defense doesn't cite any either. The defense has specific objections to certain slides because of hearsay or privilege or other things, which I'm ready to discuss at any time the court is. But as far as the summary not being admissible, there's no case law that I know of as to that. And the defense hasn't cited any either. That's all I have.
Very well. One question about the document itself. And I think this is where it goes to the heart of the defense's motion about the summary. If you were taking, say, thousands of pages of documents and you reduce them to, let's give an arbitrary number, a 25-page report, you have synthesized the larger to the smaller into something that is digestible for the jury to use in making their decision. That, or at least in putting their position, is not argumentative. Some of these things are more or less a part of the state's summary, at least as it stands right now. It's showing corroboration of other evidence. Is that in fact a summary in the sense that the statute defines a summary?
Yes, sir. I mean, this is the things that may corroborate other evidence, though, help this expert form his opinion. As the example I gave with the traffic ticket and the rental agreement, he's able to, from the phone records, say this phone is consistent with this cell site at the time. They may be this far from there, but as far as showing who has the handset at the time, like who's talking on it, and how far they are from it, it's all of those other evidence that helps him form his opinion.
Very well, thank you. Brief response if you have one.
Really brief, Your Honor. I just want to make this clear, and I think you understand our position perfectly. We're not arguing that summaries are not admissible. We're arguing that this isn't the proper summary. That's the argument. We don't make an argument in our papers that summaries are not admissible. We're saying that this document doesn't meet the foundations of the Florida statute as a proper summary. Again, they're taking particular points, but these are not voluminous documents that they're now summarizing. So there's only one voluminous document that they're summarizing in this entire presentation, and that's how they got originally to Harley Adelson's phone number, where they had data that would go to the ceiling. If we wanted to do a summary exhibit on that piece, it might be allowed. But everything else is not voluminous materials. It's a closing argument. To allow them to put that document to the jury would essentially be the same as saying, you know what, Ms. Kappelman, Ms. Dugan, when you do your closing, the PowerPoint that you do, that should go back to the jury too. Because it's essentially the same thing, Your Honor. There's no difference. That's all I have, Your Honor.
Well, concerning this motion, I'm prepared to rule on part of it today. As to whether or not Sgt Corbitt can be properly qualified as an expert witness, I will find if Sgt Corbitt is capable of testifying to the interpretation of the records that go beyond just merely where the towers are, what was pinging, and what the phone records show, that would go to scientific or technical expertise in which he is properly able to give an opinion. As to the summary itself, and I do not want to belabor this point, that I do believe I am going to need to hear from Sgt Corbitt specifically as to how he put this together, and his opinion was informed by the information that is in the summary before I can rule on it. Otherwise, I agree with the defense position. This is proper as a demonstrative, but to admit it as evidence, I'm going to need to hear more. We'll have part 2 then, in which Sgt Corbitt can testify concerning how the summary was created and how his opinions were formed by the evidence that are within the summary after we have the docket sounding next week. As to another matter in which I am prepared to rule on at this point, concerning the defendant's motion in limine, concerning testimony from Wendy Adelson as to the storyline of her book and also changing the names of the children, I will permit the state to use this information for impeachment, depending on what is developed during the examination of Ms. Adelson. As to the other matters concerning her testimony, that has already been ruled upon. Has the state also decided which jailhouse recordings you're intending to use for evidence? Because I did need to review those.
Yes, sir. As of right now, we do not have any jailhouse recordings that we intend to introduce that feature Mr. Adelson, which is what the defense was objecting to. So that's why we have not sent any to your honor. May I clarify what you just said about the name changes? You said it could be used for impeachment. She admits that point, or has previously. Would I be permitted to inquire about that, Arian?
As it relates to any prior testimony she was given on the subject, you may inquire as to that. Very well, I believe still outstanding.
Judge, I'm sorry.
Go ahead.
I just want to make sure I understand now. So our motion was to prevent them from inquiring as to the name changes. So in other words, our motion was Ms. Kappelman or Ms. Tugend can't ask her the question, did you change the kids' names? That was what our motion was. So I'm just not sure the ruling. Can they ask that question?
On that particular point, what was being offered for Ms. Kappelman?
A motive, Judge.
As it goes to motive, I will permit it for that reason, and also impeachment, depending on what comes out. Motive and bias are equally available for both parties to explore. As to the state's motion in limine, I believe there is also one other outstanding item to be addressed concerning Elizabeth Rivera's gang affiliation. As this particular point, my research lists further, Mr. Rashbaum, as to the name of the organization, I'm really failing to gather why hearing I was threatened by a gang member or I was threatened by a Latin King member is going to in some way create a greater credibility in front of the jury for the narrative that you wish to weave. I will permit Ms. Adelson, if she testifies that she acted in accordance with being threatened by a gang member, the specific name of the gang, I don't believe in any way is going to assist the trier of fact in terms of assessing her story, whether it's credible or not. They will make their determination if they believe this testimony. That is the only other outstanding matter of the state's motion in limine. As to general costs, I have not finished my research yet on that matter. Now to rule on it before we start with any selection of the jury. Do the parties have any other matters that we need to address this morning?
Yes, sir. Just a second. Judge, in contemplation, like a planning when to start evidence, can we all agree that we would not start the presentation of witnesses until Friday? The first Friday.
Assuming that we have a jury selected by Thursday.
Yes, sir.
Well, that would probably be appropriate. Does the defense have a position concerning those?
I have one moment.
Go ahead.
That's fine, Your Honor.
Very well. Assuming we had a jury by Thursday afternoon, we would start with the case on Friday. Well, will the parties be able to go to their openings, assuming there's enough time Thursday afternoon?
Yes, sir.
Mr. Rushbone? Very well. If we have enough time, then after we have the jury selected and sworn, we would give openings and then launch into the testimony from there with all the witnesses. Does the state have an idea, at least in terms of days, how long you think the case in chief will last?
I think 6 to 7 for our case in chief, Judge.
All right. Does the defense have any idea at this point?
I would say it depends, obviously, but I would think 2 days.
Very well. Nothing is going to be held fast and firm to this. I'm just asking for an estimate. Well, other matter to address with the defendant directly before we finish this morning. Ms. Adelson, next week we are going to have your final pretrial. That is typically the hearing in which I inquire of both parties if they are in fact ready to go to trial, if any continuances are necessary, and also information concerning plea offers. As I stated to you at a previous hearing, I do not prod people to take pleas. However, if you wish to consider a plea offer from the state, the time is rapidly coming for you to make that decision as to whether you desire to entertain any plea offer or not. If you want your counsel to provide an offer to the state, also the time is coming very close to a conclusion for them to do that as well. I'm not going to prod you either way, but I want you to be mindful of the fact once we begin jury selection and the denial is sworn, that means trial has started. From there, basically because of count 1, if you are convicted as charged, my hands will be tied concerning any sentencing on that matter. Your attorneys will have further discussion with you concerning this. But if you are considering anything at all, you need to make a decision on this quickly. Do you understand where I'm coming from?
Yes, I do.
Very well. We are in recess. I will see everyone next week at 9 o'clock, September 12th. Yes, sir.
Maybe we briefly go sidebar.
Yes.
Our battle pot drawer. Sure. I mean, the test space. Top. Words for it. Great hypnosis. Yeah, it sounds like a part of it. Sorry, play it. Understand. Okay, that's your doctor say again. So that's with the no confirm, but the fuck last time.
That is the conclusion of the hearing for today. Have a good Friday, everyone. We're in recess.
And how to find the possible for the push me and the one part.